You are listening to a Marcus Sahaba online radio podcast.
Time of the evening where you join us on Legal Talk, and Alhamdulillah, Mufti A.K. Hussain was, quite vociferous when he told me, Shafaat, you know what, if you got anyone this Friday, take them out. I want Advocate Feroze Boda, and I want Attorney Yusuf Docrat on, and there's a big story going on, and let them come on and discuss this issue. I said, Mufti Saab, I've already spoken to Advocate Feroze Boda, and we've agreed we can have the show. But I said, you must have our right-hand man also, Attorney Yusuf Docrat. He said, no, they're wonderful, they're beautiful people, bring them on. So topic this evening, people, let me welcome all of you, Attorney Feroze Boda, Advocate Feroze Boda, Attorney Yusuf Docrat, and the listeners were there hearty. Assalamu alaikum wa rahmatullahi wa barakatuh. Yes, I can hear that. Now, the topic, recognizing Muslim personal law in a circular state, conflict and contradiction. Beautiful topic again. Advocate Feroze Boda, there you are. I see you have a big file in front of you. It's like going to be a big case this evening. I don't know how you're going to handle it, but alhamdulillah, tell us, how are you doing this evening?
Alhamdulillah, I'm fine, Brother Shafat. I hope you're okay and everyone is listening also, inshallah.
Alhamdulillah, yeah, we have them all. Millions of them around the world. The podcast is going to go all over. And Attorney Yusuf Docrat, how are you doing this evening?
Alhamdulillah, I'm doing very well. Thanks, Brother Shafat. Hope you and all the listeners are well.
Yeah, our stock rises when you guys are with us. And yes, Advocate Feroze Boda, starting off, perhaps, give us a summary of what has happened thus far and give us a picture. How deep are we going in this evening?
Okay, so I'm going to give you some historical information leading up to the case that was argued yesterday in the Constitutional Court. So in the apartheid era, the apartheid government said that Muslim marriages were illegal because they were potentially polygamous, and they were therefore against public policy. So even though it was a contract, the contract was illegal because it conflicted with what you call the boni mores, or the values of the society, and that society was the apartheid society, which was very rooted in Christianity. And because of what the courts felt was the potentially polygamous nature of a Muslim marriage, because the default position, obviously, and the position in Islam is a man can have 4 wives. So that offended the morality of the apartheid government and the very concept and notion of polygamy. And therefore, they declared the Muslim marriage to be invalid. And what that meant was that you couldn't go to an apartheid court to enforce any rights in terms of Sharia. So what used to happen, there was very evil things in those days. So, for example, I know of cases where, because the marriage is not recognized, in the case of a divorce, for example, a woman would get a wife would get her father or some other relative to adopt the children, to prevent the father from excess rights. So if the father wanted excess rights, he couldn't get it because adoption, in terms of the apartheid law and our secular law, cuts the relationship between parent and child completely. And that was the consequence of not recognizing marriages. By the same token, Muslim women would not, who wanted maintenance in terms of Sharia during the marriage, if the husband wasn't supporting them, or after the marriage for the Iddah period, or wanted to enforce whatever rights that they were given in terms of the Sharia against their husbands, couldn't go to court, and therefore faced injustices because their rights were trampled on and they were not recognized. And so you had an entire system where Muslim marriages were being, because of the fact that they were not recognized by the apartheid state, you had all of these injustices that were happening. So that gave rise to a call in the new democratic order to recognize Muslim marriages. So it is a very well-intentioned call, and it had a very a good background of good reasons for the call as to why it should be recognized. So then you had many attempts by the government to try and pass or draft legislation, and there was initially a Muslim personal law bill that was given out for public comment, and it sought to recognize Islamic marriages. But if you look at that bill, what it did was then, in recognizing Muslim marriages, it realized that there's going to be a conflict between the Constitution of South Africa, which is the supreme law of the land, and the Constitution says anything in conflict with this Constitution is invalid. Anything that breaches a Bill of Rights, like the right to equality, is invalid and therefore cannot be enforced. So they recognize, the drafters of that bill, that there's going to be some tensions between the Constitution and certain provisions of Islamic law looked at in vacuum without the total system of Islamic law being taken into account. And so in the draft bill, they sought to introduce certain things to try and marry the Islamic marriages with the Constitution, and that really was an attempt to mix oil with water. Because, for example, one of the things they did was in the bill, and they basically said that for example, polygamy, you couldn't get married to another woman unless you got court permission, and before you got married, the court had to sanction that marriage. And in the court permission process, you need to join your first spouse, or if you have more than one spouse, your other spouse, and then you can only get married if the court gave permission. And if you got married without court permission, you would be liable to a fine of 100,000 rands, for example. So that was one example where now already you see the problem here, because there's no restriction placed on. There's a condition of justice in the Quran, but that condition is always left for the men to fulfill after the marriage. It cannot be judged post or prior to the marriage. It's something that the man must fulfill after the marriage. And a man, if a man fears that he cannot do justice, then the Quran commands him only to take one wife. But it's really left. And if you look at the practices of the Prophet ﷺ and the Sahaba, there was never any evidence even of a Sahaba getting permission from even the Prophet ﷺ to get married to a second wife, or taking permission from each other, and even in the time of the Khulafa Rashidin, it was not something that you had to go to the government before you did this in order to take another wife as in your marriage. So the introduction of the requirement that court permission was required is something that is foreign to Islam when you look at it in a traditional sense, and also the criminalization of polygamy is also foreign to Islam, because the immediate conundrum that the law then faces is that if a Muslim man in a single marriage has an adulterous affair and takes a mistress, the law doesn't punish him. But if he takes a second wife without court permission, the law punishes him. So adultery is not punished, but polygamy without court permission is punished. Then you had another problem with the draft bill. Is they basically in the draft bill gave certain grounds for the dissolution of a marriage. Now, I'm not an alim, so you take my Islamic knowledge for what it is. I've consulted with ulama, I have a layman's understanding. You must check what I say with whoever, who the scholars are. But from my understanding, being part of the faith, you can dissolve an Islamic marriage in a number of ways. The general power is the man has the power of talaq. And we all know how that operates. Ideally, terms of the Quran, you need to separate the talaq over the iddat period. But the scholars say 3 talaqs issued in one go it ends the marriage, and that means that you can't get married again after 3 talaqs without the wife getting remarried and then divorced. So the usual default position in Islam is that marriages are dissolved through a talaq, and after the expiry of the iddat period, then the marriage is dissolved, and then the parties, if that happens, are free to remarry. So it doesn't require any court intervention or decree of divorce or stamp of approval for the court before the talaq or the marriage is dissolved. Once the talaq is issued and the iddah period ends and it's finalized, the marriage is dissolved. It's like a contractual cancellation of a contract. It's the end, and the parties are free to remarry. That's one way of divorcing. The other way of divorcing in Islam is through a khul, right? So the wife will go to the husband and she'll say, I want to dissolve the marriage or want to annul it by agreement. And they will come into an agreement, a contract, where by their agreement they'll decide to dissolve the marriage in return for whatever arrangements they make between themselves. And once they reach this contract, then after the khula takes effect and the iddah period, the marriage is ended, and that's it. And the third way of dissolving a marriage is through fasq. So if a woman is in a marriage, for example, and her husband does not want to give her a talaq, then the woman in an Islamic system can approach the court and ask the court to dissolve the marriage on recognized grounds. Now, in the secular law, one of the main ground for dissolving a marriage or granting a divorce is if there's an irretrievable breakdown in the marriage. The court will then grant the divorce. Now here, the ground of irretrievable breakdown of a marriage, whether that is compatible with Islam, is a debate. So some ulama that I've read and consulted say it's fine, it's compatible with Islam. If there's no love, for example, a court can dissolve a marriage. But other more stricter ulama say no, there are certain very strict grounds for fasq. For example, a man is not fulfilling his marital obligations, is not supporting the wife, is ill-treating her and which in a manner which is unacceptable in Islam. Then the qadi will have the right to issue the fasq at the instance of the wife and dissolve the marriage. So some of the ulama, and I don't know what is right, I'm not a scholar, but some of the ulama who held to strict schools of thought basically said you can't extend the grounds for fasq by this broad irretrievable breakdown of a marriage ground. So that's going to lead to an incompatibility between Islam and the law. And then also we have different mazhabs. So how do you accommodate the different mazhabs in a piece of legislation? Because when you draft legislation, you're going to have to now try and codify the law, which is very difficult, and then that prevents you from judging a case on a case-by-case basis. So that brought about the conflict. Then another area of conflict was maintenance after the dissolution of the marriage. So my layman's understanding is that a man is obliged to support his wife for the iddah period, and after that there is no legal duty of support. There's nothing. So in an Islamic system, after the iddah period is ended, a woman will not be able to sue her husband for maintenance after the marriage. Whereas in the secular law there is room for that under the Divorce Act, and so some of the things in the proposed bill sought to grant women the right to claim benefits beyond the iddat period from her husband. And now this is a form of changing the law, and it's also a form of zulm in the sense that in an Islamic system there are certain rules. A woman is never left alone in an Islamic system. So if she's divorced, she can always claim the duty of support from her father or her elder brother or her uncle. And if there's nobody there, she can actually claim the duty from the state. The state will have to support her. But in a secular system, you can't go to court and say to the government, I'm a destitute widow and I want you to pay me maintenance, the government shirks its responsibility. So what happens when the government shirks its responsibility to look after widows in the society is that now it must look for some other person to transfer this responsibility to. So beyond the iddah period, they transfer it to the men. And that is a form of oppression from an Islamic perspective. So here again, you have a conflict between, strict Sharia law, and you have a conflict between a bill that now tries to mix and mesh Sharia in a form which is now constitutionally acceptable. Then you have the age of marriage. So the bill will set an age of marriage, but in Sharia, once you reach puberty, you are entitled to get married, and so selecting an age of marriage is now again something that is not viewed as consistent with Islam if it is something above puberty. And so these are just some of the examples where the bill that was mooted, and one of the fundamental problems with the bill that was mooted was that it basically allowed a court to dissolve a marriage where the judge dissolving a marriage was a non-Muslim judge. So there's a principle in Sharia, and this is what we learned from the ulama. I'm not educated in this, but what we learned is that it's impermissible for someone who does not believe in Islam to sit as a judge in a dispute between two Muslims and to dissolve the marriage. It's not recognized in Sharia. The judgment itself is not recognized because the person applying it will not be applying Sharia law or not believing it, and therefore the person is disqualified from sitting as a judge in a marital dispute. So how do you resolve that problem where non-Muslim judges are sitting in judgment and dissolving marriage? Then you had another tension because in the secular law, a divorce only takes effect when the court decrees. So you have cases, and you've had cases where the marriage is over because the talaq has been issued and the iddah is over, and the woman claims maintenance beyond the iddah period, and the court says, I don't recognize the talaq, the secular court, because the talaq is only effective when I approve it. And therefore it deems the parties who are actually no longer married for purposes of Sharia to be married to enforce a claim of maintenance. So all of these difficult problems occurred as a result of trying to draft a piece of legislation to make it in conformity with the Constitution. So that process was jettisoned. So what then happened is that there's a lobby group or certain groups within the Muslims within South Africa who still want the state to pass this legislation to recognize and regulate Muslim marriages. So then what happened was there were two cases that were taken over and that were advanced by the Women's Legal Center Trust, and there were certain ulama bodies such as UQSA who supported this application, who went to court to basically compel the government to enact legislation to recognize Muslim marriages. And here now you had the differences between the various groups, because you have groups like Lajnatul Islam, who was one of the parties in the case. You have, for example, the Muslim Lawyers Association have been on record saying you cannot compel government to pass legislation because of all of the problems in trying to harmonize the Sharia with the Constitution. And it's like mixing oil and water. You're going to have a clash of values. You're going to have a change in Sharia. You're going to have non-Muslim judges interpreting the Sharia. They don't know Arabic. How are they going to interpret the Quran? How are they going to interpret the Hadith? How are they going to select between Hadith which will require reconciliation? You can't do that from a translated book. You can't translate the Sharia into English and enforce it through an English statute. It is unheard of, because the Sharia is basically sourced within the Arabic language, and you can't then interpret the verses of the Quran if you don't know Arabic. Basic stuff like this. So how are judges going to sit and enforce the Sharia when they're not even qualified, they don't even understand Arabic, they don't understand the Quran, they don't understand principles of usul al-fiqh, they have no access to the knowledge through classical works, because it would have to be translated for them, all of these problems. But nevertheless, the Supreme Court of Appeal gave the following order at the instance of the WLC, and the order basically says that the Marriage Act and the Divorce Act is declared to be inconsistent with sections 9, 10, 28, and 34 of the Constitution, for example, equality and dignity and other rights, in that they fail to recognize marriages solemnized in accordance with Sharia law, Muslim marriages, as valid marriages which have not been registered as civil marriages, as being valid for all purposes in South Africa, and to regulate the consequences of such recognition. So the Supreme Court of Appeal said Parliament is obliged not only to regulate and recognize the marriage, but to regulate the consequences of such recognition. And then they said it is declared that Section 6 of the Divorce Act is inconsistent with Sections 10, 28, 34 of the Constitution, insofar as it fails to provide for mechanisms to safeguard the welfare of minor or dependent children of Muslim marriages at the time of dissolution of the marriage, in the same or similar manner as it provides mechanisms to safeguard the welfare of minor or dependent children of other marriages that are being dissolved. Then they said it is declared that Section 7.3 of the Divorce Act is inconsistent with Section 9, 10, and 34 of the Constitution, insofar as it fails to provide that at the dissolution of a Muslim marriage for the transfer of assets of a spouse in a Muslim marriage where such spouse contributed directly or indirectly to the maintenance or increase of the estate of the other party during the subsistence of the Muslim marriage, either by the rendering of services in the saving of expenses which would otherwise have been incurred or in any other manner. So here it is, you have a room to force maintenance beyond iddat and to force proprietary consequences of a marriage. Islamic marriages are out of community. But you have a mechanism to divide the estate in an equitable manner if these things happen. It is declared that Section 9 of the Divorce Act is inconsistent with the Constitution, as it fails to make provision for the forfeiture of the patrimonial benefits of a Muslim marriage at the time of a dissolution. So in other words, in terms of secular law, one person can forfeit the patrimonial benefits of a marriage on certain grounds, and that is a whole issue in Islam. I'm not sure if that even exists. The ulama will be able to advise better. And basically then, what the court basically said is that pending the coming into force of legislation or amendments to existing legislation, the court basically said the Divorce Act is applicable to Muslim marriages, the Interstate Succession Act is applicable to Muslim marriages, in short, and pending the outcome of this, those things will regulate Muslim marriages. Muslim marriages will be recognized, and you must enforce your rights through the Divorce Act and the Interstate Succession Act. Now, here we're gonna unpack some of the difficulties with this interim order to illustrate some of the inconsistencies. But that's the background. That's where we are. So you have two schools. One saying you can't. If you're going to recognize Muslim marriages, you recognize it in its pure form, with all the consequences. You don't modify it in terms of the Constitution, and you allow Muslims to judge their own marriages. You allow for arbitration, or you create Sharia courts where Muslims are presiding qualified people, and they will have the right to make decisions. So you give them complete freedom. You give complete freedom to Muslims, where they are entitled to enforce their laws in accordance with the Quran and Sunnah, and entitled to do so by recognized ulama bodies, arbitration tribunals, or a Sharia court which was created. The other system is no, that's not possible. So we're going to recognize Muslim marriages, we're going to force Parliament to regulate it, and we're going to let the secular courts decide all of these marital issues: maintenance, proprietary consequences, custody, obligations after dissolution, grounds for dissolution, all of this. And among this, many, many questions arise. Who is a Muslim? That in itself is going to play out in the courts. What happens if somebody believes in gay marriages and they say it's justified in terms of their version or interpretation of the scriptures? You have crazy people today who come up with all sorts of nonsense arguments to that effect. What's going to happen then with all of these things, and how are the courts going to interpret Muslim marriages and give it effect? They're actually going to land up changing it and secularizing it. And so that's the heart of the problem that we face, and that's the heart of this case, and that's what the Constitutional Court is to decide whether this order is going to be confirmed or not. So I've tried to summarize the history, and I think in the next part we'll get Brother Yusuf to look at some of the principal issues involved in this tension that I hope I've tried to make clear. Jazakallah. It's been a bit long, but it had that long history.
But it wasn't long. It was brilliant indeed, and I can tell you the conundrum. Hey, you put me in a conundrum, but you are, you're filling us in so beautifully, and we're really enjoying it. Advocate Feroze Boda, Allah bless you for that. Time for us to go for a break, and when we get back, inshallah, Advocate Yusuf Docrat will be giving us his summary also, or his points of view on this critical issue. Let's go take a break.
You're listening to Marcus Sahaba Online Radio Podcast.
Still having a fantastic conversation with our advocate Feroze Boda, and yes, I tell you, Attorney Yusuf Docrat is going to take a limelight now, recognizing a Muslim personal law in a circular state, conflict and contradictions. And I tell you, Attorney Yusuf Docrat, our advocate really, he laid down, he summarized it so beautifully. It makes for fascinating listening to us as the ordinary layman or the person that's listening to this. And adultery is not punished, but polygamy is punished. Things like that staying in the back of my mind, talking about the different mazhabs. Brilliant indeed. The principles are that governing this. What are the different principles, the principal objections? Perhaps you're going to fill us in on that, Attorney Yusuf Docrat. Bismillah.
Yes. Assalamu alaikum wa rahmatullah. Bismillah ar-Rahman ar-Rahim. Thanks, Shafa. Just flowing from your comments, the example that you used that Feroze had raised about criminalizing a failure to register talaq and then allowing and not criminalizing an act that Allah Azza wa Jal considers a heinous crime. Perhaps that's a good place to start, because what it does is it reflects quite profoundly this incredible difference in values between Dinul Islam and any other system, and in our discussion for our purposes, the secular system. And this clash of values plays itself out in the life of Muslims living under the rule of secular law on a daily basis. And we find ourselves constantly having to check our conduct, but more importantly, check our mindset in relation to why we do certain things, what approach we take to certain things, what informs those decisions. And Brother Shafa, this is something we may have alluded to in previous discussions, but it's something that is the thread that weaves through our lives that we've got to be very clear about. What do we mean when we say we are Muslim? What does it mean to be a Muslim? And this issue of identity will affect everything else that we do and think in our lives. Absolutely everything comes from how we understand who we are. So if you have a person who says, I'm a person who's governed, who believes that the Constitution is the ultimate set of values for me, then you know what decisions that person is going to take in relation to most things. If you have a person who says, I'm a Muslim, and I believe that there is one Allah, and that the Prophet ﷺ is the final messenger, then you know that this person is going to be infused with that sense of identity as a prism from which to view everything that takes place. And why is that important in our discussion? Is because when we speak about Muslim personal law, Sharia versus secular law, let's give the Sharia its proper estimation and its proper status. This is the law of Allah Azza wa Jal. This is not the law of you and I. This is not the law of esteemed professors. This is not the law of activists. This is not the laws of justice seekers. This is the law of the Lord of Lords. This is the law that Allah Azza wa Jal has seen fit to place upon the earth for insan to follow. And if we don't recognize that supremacy, if we don't recognize that autonomy that Allah has in relation to His law, we will get lost in the debate trying to reconcile Sharia with a system that denies Allah. You cannot reconcile the two systems. Their philosophical premise, their value premise is completely apart. So as a kind of textual example for you, Brother Shafar, if you look at the opening words of the Constitution, it says a number of things, but one of the things it says is, and South Africa belongs to all who live in it. Now, politically that sounds nice, the country belongs to everybody who lives in it. But that in itself is fundamentally opposed to our concept from Al-Quran about ownership of the earth. Does Allah not say that the earth belongs to Him? So right at the beginning, you have a notion that He is opposed to each other. Does Allah not say to us that He rejects any system other than His system? And if we don't appreciate that, we will seek constantly to try and manipulate the principles of our deen in order to make it consistent with another set of values. Now, if I were to say to you, so you get people who say, but let's try and find common ground between secularism and Sharia. Don't be so uncompromising and don't be so extreme in your views. Let's find common grounds. I've already indicated to you why we can't, purely from a premise point of view. But let me ask this. Will you ever say, let's find common ground between halal and haram meat? Will you ever say, well, they're not really so different because they're both meat? What makes the one despicable and the one pure? What makes the one filth and the other one tayyib? Is it not the law of Allah? And so, if I were now to say, all right, so let's change the law of dhaba and let's change this because it needs to be constitutionally acceptable X, Y, and Z, are we going to allow that? Of course not. We're never going to allow it. So why are we entertaining the discussion on a watered-down version of a law that we have no right to interfere with, the law of Allah? Why do we even begin to entertain that discussion? One of the problems that one has living under a law other than the law of Allah, is not to recognize the fact that Sharia, its primary sources being Quran and Hadith and then all the other accepted principles that flow from fiqh, is a multifaceted, extremely complex, superbly crafted, independent system that cannot be placed under a system that purports to regulate the same things in people's lives. We don't think of the Sharia as this incredibly complex system. We have a tradition of scholars who had spent the greater part of their lives, and when we say the greater part of their lives, we actually mean the greater part of their lives. 10, 15, 20 hours a day without sleep, studying, in salah, seeking guidance, debating, trying to understand all of these issues. And we think, as people living in South Africa in 2021, that we can just kind of flip through one or two articles and say, I think that scholar was a patriarch. And that is just incredibly presumptuous of us. It's deeply arrogant of us to take away from this deen the incredible richness of our jurisprudence. and to seek to place the jurisprudence under a constitution that has absolutely nothing in common with this deen. And then to have the temerity to say that we're doing it because it will serve the interests of justice. Is that adl? Is that qist? Is that justice? How can that be justice? How can the mellowed down version of the Sharia, or even worse, the perverted version of the Sharia, ever bring justice to a society? So, Brother Shafat, we saw this happening in the last 18 months, where so much of how we view legislation, how we view the world, how we view what is happening, is influenced by our identity and the way in which we view this deen of Allah and the Sharia. So, what are the conflicts? The conflicts are not only profound, they're not only manifold, they pervade every area. Because Tawheed pervades every single area of Sharia, and disbelief pervades every single area of secular law. How do you want to merge them? How do you want to sit and say, I can be... So we hear, for example, in Europe, the dhulm of the French government saying, we want people who are Muslim to espouse and openly commit themselves to having French values. Now, rightfully, we find that offensive because we know that French values, in the way that they understand French values, is diametrically opposed to the values of Islam. Do we want to place ourselves in the same situation without being compelled to do so, where we start saying our deen is such that we are able to embrace the values of something completely foreign to Islam? We can't do that. And we must recognize what we are doing it. And we must take it seriously. Because wallahi al-azim, this is not simply a question about individual lives. This is a question about aqeedah that is going to have an incredibly profound effect on the present society and our descendants. What do we want them to inherit? A system where that is called Muslim personal law, but if you dig beneath the veneer of Muslim and Islam, is in fact nothing like it? Do we want them to inherit that? And to then, for the rest of their lives, believe, and this is what happens when legislation is there long enough. It gets legitimacy. This is what happens when consultations take place with state authorities and so on and so forth. You legitimize the process. And then are you going to legitimize that process and then be grateful because now you've got rid of patriarchy from Sharia? Is that what you really want to achieve? We need, as an ummah, to understand that the only distinction that is relevant for our lives is the distinction of belief and disbelief. And that manifests itself in the most visual and noticeable way in legislation. And when we choose secular law over Sharia law, we are committing a grave offense. And when we claim to be introducing a degree of Sharia law under the secular law and achieving the very opposite, then our offense is in fact more culpable. So, Shafat, I hope that in some way establishes how critical a question this is, that all Muslim brothers and sisters in South Africa need to think about. Think very carefully about it. We must make dua to Allah that we do not get caught in worshipping our own minds, thinking that we are so clever that 1500 years on, we understand things about Sharia that the great scholars of Islam didn't. That we understand things about Sharia that the Sahaba radiallahu anhu didn't. We need to get rid of this arrogance that is beginning to creep into the society. And if we can do that, and if we can come back to the question of Tawheed and give Allah His true estimation and give His law His true estimation, then inshallah Allah will have mercy on us. Feroze, I think maybe you can add to that substance that you need to.
Okay, Feroze, before you get into that, I want to compliment our Attorney Yusuf Docrat for being, so concise also, just like you, both of you compliment each other. He talks about the kalima being the identity and, the law of the law of Lord. I love that, a beautiful line that one time, it actually outdoes Shakespeare or whatever work you do, but the laws of Allah subhanahu wa ta'ala. And you remind me of an anecdote which states, the things of this world proceeds by divine decree and not by man's administration. And, you said it eloquently again, we cannot reconcile the circular and the divine law. Definitely, divine decree will supersede all. People say, let's find a common ground. I love that between secularism and Islam. Virtually impossible. And you give the example of halal and haram. Meat. Halal meat is halal meat. How can you find a common ground? Bacon and bacon, or you can't do that. Halal is halal and haram is haram. So you cannot find that, the middle ground. You go on to say scholars who spent hours in jurisprudence under divine law, praying, meditating to implement Allah's law on this earth in accordance to the Quran and the Sunnah. We cannot have this watered down. Neither can we have it judged on or judged by people that don't know nothing about the deen and who, some maybe just read a paragraph on something and they think they know it all. That can never be. And you brought in the French values diametrically opposed to Islam. This is a question of Aqidah which will have an impact on our descendants, and alhamdulillah we should be defending it. We need as an ummah to realize that there is a major difference between belief and disbelief. Beautiful indeed. Advocate Feroze Boda, your comments.
Jazakallah khair. I mean, Yusuf has expressed the conflict in so graphic terms by that example, and you see that type of conflict playing out. And we'll give some examples also of, the conflict playing out with respect to the order that the Supreme Court of Appeal made a little later on. But I just want to add to certain things that Yusuf said about, our approach to matters of this nature. So what is at stake and what is being compromised in the process? And really, this is the fight of deen, the fight of Islam versus kufr, the fight of darkness versus light, the fight of truth versus falsehood. We are Muslims because we believe that the deen is true and we submit to the deen. And when we say we submit to the deen, we don't submit to the dictates of our opinion, of our cleverness, or the opinion of anyone else other than Allah and His Rasul, and what our scholars have agreed on in the past as being ijma, and that portion of the law was simply there to give effect to the Quran and Sunnah. So I want to pick up on certain material differences between secular law and Islamic law, just from a shall I say, theological perspective. So the first difference is the purpose of law itself is very different in a Sharia system versus a secular system. And all of these reasons will go to why the two cannot be married or matched or even harmonized. So in a secular system, all law is there to attempt to serve justice. But the notion of what justice is, and the concept of justice, secular justice, Islamic justice, is very different. And the primary reason for this difference is this. In order to understand anything in Islamic law, any fiqh or any rule rule, for example, the rule against adultery, in order to make sense of it and to understand it from an Islamic perspective, you can only make sense of it if you believe in two worlds, this world and the next world. So you believe that this world is a medium to get to the next world, and that true life true accountability, true justice will be served on the day of Qiyamah. And what you do in this world will ultimately determine, subject to Allah's will, of course, what will happen to you in the year after. And in the year after, we know as Muslims, we believe in heaven and we believe in hell. And that's where we'll end up. We'll either be in one of those two places. Ultimately, we'll serve in the dungeons of hell, or we'll serve in the beautiful gardens of Jannah. So every law in Islam has a very different purpose to secular law. Every law in Islam serves to drive its citizens away from Jahannam and into Jannah. That is the purpose of law in Islam. So why is adultery criminalized in Islam with a harsh punishment? Obviously, there's a very strict standard of proof. Why is there a hard punishment for theft? Why is there a hard punishment for robbery and for murder, provided the Islamic requirements are fulfilled? Because all of these acts are heinous sins in the eyes of Allah and could lead you to destruction in the year after. So the reason that you have laws, and the reason that laws are passed in an Islamic system are there not only to look after the welfare of the citizens in the dunya, but more importantly to ensure that they are driven. That's the task of the ruler, to drive his citizens into Jannah if he can, to move them towards Jannah and away from Jahannam. So the purpose of Islamic law is not only to look after the welfare of those people in the dunya, but to attempt to look after and safeguard their welfare in the akhirah. And so when you have these two systems, one believing in the hereafter and one negating the year after, one believing in Allah and one negating Allah, one believing in Jannah and Jahannam and one negating Jannah and Jahannam, one believing on the day of Qiyamah and one negating a day of Qiyamah, you cannot harmonize them. The one is truth and the other is falsehood. So the very purpose of Islamic law and all of the rules that we have in the Quran is ultimately to submit ourselves to Allah's law and to submit and to be good Muslims so that we are secure in the hereafter. So all of the rules that we have in the Sharia, family law, criminal law, commercial law, all of them have this two-worldly outlook. And there's no way a secular judge will ever be able to appreciate the wisdom of anything in the Sharia without believing in Allah and believing in the day of accountability and believing in the hereafter. So that is the first primary difference between the two systems at a very conceptual level. The second difference is about authority. Who has ultimate authority? Now, in the secular system, that has ultimate authority in the form of the ruling party. In the Islamic system, it's Allah who has ultimate authority. And I'm going to read something by one of the scholars, Maulana Farhad, which captures this point so beautifully about the competition for power in a secular versus in a religious Islamic system. And he says the following with reference to MPL. I want to give this quote and another quote from another book to illustrate the point about the competition for true authority and the making of law. And he says the following: whatever the justifications and challenges, ultimately the proposal and attempt in the article that is to promote MPL legislation is to take divine law selectively by our whims, or even if totality, and place it under the jurisdiction of secular law. Now, the reality of the universe is that Allah created it by Himself, takes care of it by Himself, and holds it accountable to Himself. He has made His obedience incumbent on the universe. He and only He decides what is right and what is wrong. He has precisely dictated what is expected and obligatory upon His creation. He makes the law. The secularists and all those who do not submit to His law are competitors to Allah on the earth, in that they wish to draw the obedience of Allah's creation to themselves instead of to their true master. They are therefore the enemies of Allah. It is therefore easy to understand why subjugation of Allah's law, while sanctified as Allah's law in part or whole, to other than Allah, is a sacrilege of His law and is an act of blasphemy. If certain categories of Allah's law, or even one law, can be subjugated to other than Allah, then why not more categories or more of His laws? What then is the meaning of establishing the lordship of Allah on the earth? So there's a competition for power. We believe Allah is in control, and they believe the government is in control. The second essential difference about legislative authority in modern systems versus Islamic systems is this. And this is taken from a book by Abdul Hakim Murad, Traveling Home, where he points out that classical Sharia agrees that the ruler has virtually no control over legislation. God's law is found, interpreted, and actualized by the Muslim populace through their expert representatives, who are the ulama, who must, as a matter of necessity, be independent of the ruler. So what he's saying is that in Islam, you never had a system where the ruler would make law, interpret law, or enact law through legislation. You don't find this. You find this very late when the Ottomans took over and vast parts of the earth and codified the Sharia law. But if you look at the times of the Khulafai Rashidin, they never legislated and had legislative councils and codified Muslim personal law into a statute. Well, why didn't they do that? Because it was never the role of the ruler to dictate to people what the law is, because the law is already dictated by Allah. And so it was simply for the jurists to apply the law on a case-by-case basis to give justice to the parties. So the very notion of codifying Muslim personal law into a statute, and now not even in a Muslim system, but in a system where people who disbelieve in Islam are doing the codification, is completely foreign to Islam. The whole political system is foreign to Islam. So that's the second key difference conceptually. We'll take a break, Brother Shafar. I want to highlight two other key differences, and then we can get into the detail, inshallah.
Inshallah, Jazakallah khair for that, Advocate Feroze Boda. Yes, it's time for us to take a break and go for the Isha Azan, and inshallah, we will continue after that.
You're listening to Marcus Sahaba Online Radio Podcast.
Welcoming a pious and sagacious ummah after the Isha Azan with a hearty Assalamu alaikum wa rahmatullahi wa barakatuh. Advocate Feroze Boda with me, and also our attorney Yusuf Docrat, both giving us a brilliant input this evening. Recognition of Muslim personal law in a circular state, conflict and contradictions. Before the break, Advocate Feroze Boda very eloquently, he spoke about fight between light and darkness, and always light will come to the fore, and we submit to the Quran and the Sunnah of Allah subhanahu wa ta'ala, Atiullah wa Atiur Rasul. We believe that we use the medium of this world to go into the next world, either entering heaven or hell. We are a physical being having a physical being or a spiritual being having a physical experience, but we'll go back to our spiritual world, inshallah. And he talks about heinous sins are mentioned as a warning, so believers will abstain and gain divine blessings, and those that negate Allah's law will never appreciate Allah subhanahu wa ta'ala's deep blessings on us and His guidance and His mercy on us. To disobey Allah's law is at a time it can actually lead to blasphemy. And the ruler, during the time of the Khalifa or the Sahaba radiallahu anhum, the ruler never dictated the law, because Allah's decree was followed, divine decree was followed. Advocate Feroze Boda, you were, mashallah, conscientizing us. Proceed, bismillah.
So I was dealing with the second point about legislative authority and the competition for legislative authority, and and the point that the two scholars made. But I want to just carry on reading from what Sheikh Abdul Hakim Murad said about the very idea of legislating Muslim personal law into statutes being inimical to the way law was practiced by our communities. And he says, in the classical Sharia, local communities were expected to be largely self-regulating. By contrast, Following the British Raj's decision in the 19th century to turn personal status elements of Sharia law into statutory laws, Western-educated Muslims slowly adopted the idea of religious law as something to be interpreted and enacted by the legislature of a nation-state. The result has been systematic failure everywhere, together with a substantial loss of the Sharia's diversity, the madhab system, and the independence and hence the moral authority of many ulama. Every Muslim polity which has attempted to westernize Islam's ethico-legal vision by reinventing Sharia as statutory law has created a totalitarian ideological state which, by turning Islam into a Prozarectian bed in the longer term, becomes a tragic Ridistan in a global energizer of tanfir. So that is so beautifully capsulated by Sheikh Abdul Hakim Murad as to why it is completely inimical to the flexibility of how Sharia operates, to the role of the ulama, who are the custodians of the law, because the law is already enacted. It is for them, after years of study, to apply the law based on their knowledge, based on particular circumstances of a case, and to give rulings on a case-by-case basis, which results in flexibility and diversity and allows justice to be met out in given situations. The very notion of now codifying the law into a statute and asking judges to now interpret the statute takes away this flexibility that the ulama have, and in fact usurps their role. Those people who are punting for legislation have a problem with our ulama making decisions on the basis of Sharia. They have problems because some of them have feminist beliefs that men who are in the position of ulama can't be just, which is really completely inimical to our values, because nothing makes a man incapable of doing justice to a woman when he's applying the law of Allah objectively. As women can do justice, so men can do justice. But they have a fundamental problem. They want to take away the power of the ulama to make judgments on a case-by-case basis in the community and transfer it to the political judiciary in this country. And that is completely inimical to Islamic law. The third fundamental difference between secular law and Islamic law is that secular law believes in the notion that values change from time to time. So if you look at in the 80s, there was the concept worldwide almost of the marital power, the husband being in charge of the family unit. It was also a recognized thing in South African law. It was only abolished recently. The qawam of the man was something that was recognized in the family unit in all systems, but because of liberalism, because of the idea that values change, because of the idea that man is progressing and that the old values are archaic, there's a belief that everything needs to be reevaluated. So everything we believe in, hold on tight to, has to be reevaluated. So for example, today, liberals are questioning the idea of who a man and a woman is. They're questioning the concept of gender. They're saying that gender is not determined by your physical features, but a man can inside be a woman today and a man tomorrow, and a woman can be a man, because gender is determined not by your physical features, but by your mind or your state of mind. So even today they're questioning the role of gender. They're questioning the concept of marriage. The concept of marriage in Islam is between a man and a woman, because Allah has created them in pairs, because Allah has chosen to create a man and a woman and to worship Him in the ways that He's prescribed that they should worship Him. Today, they change the concept of marriage and say a man and a man can get married, and a woman can get married. And they're also going to, in future, accept and have to accept, because of the liberal mindset, that a man, a woman, a cat, a dog, a mother, a father can all have one marriage and all can become a spouse because they have decided contractually to carry on and engage in this marriage, and they're going to ask for legal recognition. And they're going to then later on ask for legal recognition of marriages between brother and sister, and they're going to ask for legal recognition of marriages between mother and father, mother and son, and daughter and father. So because they believe in the concept of changing values. In Islam, our values are the same. Allah created man and has not changed the value system. So when we look for our values, we look backwards, because the Quran tells us that the earliest nations there'll be more of the earliest nations in Jannah than the later nations, because they understood what Allah wanted from them better than us. And when we asked, when the Prophet ﷺ sought to guide us, he said to the people, follow my Sahaba. Follow any Sahaba like stars in the sky. And he said, follow the 3 generations after me. Follow, and all our 4 Imams come from that generation. All of the schools of Madhab come from that generation. Because they understood Islam in its pure form and practiced it. The Sahaba first, the Tabi'in, then the Tabi' Tabi'in. We look at them to determine our values, because we understand that they understood the Quran, they understood the prophetic practice in a purer sense than we can understand it now. So when we search for values, we look back. When they search for values, they look forward. So the two are completely oil and water. You cannot blend secularism with Islam. The two are completely incompatible. And ultimately, what does this ultimately conclude? And really, although the systems are different, our test is the same. What were the generations of Muslims after the Prophet ﷺ? What were they tested with? They were tested with one thing. If you look at history, with the protection of the purity of the deen. That's what they were tested with. That is the eternal test of a Muslim. So if you look at the time, for example, of Abu Hanifa or Imam Ahmad bin Hanbal, all of them were hanging fast onto the rope of Allah and to the principles of the Quran and Sunnah against the wishes of the ruler. They always separated themselves from the ruler because they knew that the ruler, because of political expediencies, will seek to corrupt the deen. And so their task, and the task of the Ummah, was to hold firm to the principles established in our deen by the Quran and the prophetic practices and the earlier generations of Muslims. And that test was carried on when Imam Ahmad, for example, they were confronted with this idea that the Quran was created and therefore fallible. And this was an idea mooted by the rulers because they wanted to claim political authority to determine what is right and wrong, and they wanted to make laws that trumped the Quran because they believed that because it was created, it may have mistakes. And Imam Ahmad stood up at the pain of imprisonment, and some of his colleagues were put to death. And he stood up and he said, I'm going to protect the Sharia. I'm going to protect the status of the Quran. I'm going to protect the status of the Sunnah and the Hadith. I'm not going to change one thing. And if they're going to put me to death, so be it. I'm going to stand fast and hold on to the rope of Allah. And that test is, if you look at the generations of tests that the Muslim Ummah has faced, that test has been a consistent test. Every Muslim has a duty to protect and uphold the Sharia, to stand firm on its principles, and to make sure that we will never compromise the deen under any circumstances. And we are prepared with the will of Allah to give up everything for the protection of deen. And many people who punt for changes in the deen forget that the first maqasid of the Sharia, the greatest role of law in the Sharia, is the protection of the Sharia, even before life. So that is why, for example, sometimes you have to, jihad is compulsory for the protection of deen. So the protection of deen is the first duty of a Muslim. And that is what we are here on this earth to do. And that's why these tests that we confront in modern times, that we've been speaking about before, the test of closing masajids, who's got the authority to do that, changing the way we make salah, splitting the serfs, and now creating new personal laws which are completely foreign to the laws enacted by the Quran and the Sunnah of the Prophet ﷺ. All of that is a consistent test, and it's for us to hold on to like hot coals. We're going to have to hold on to this deen, because that is our true challenge. And inshallah, that was just to take forward what Brother Yusuf has said. I don't know if he wants to add anything to what I said, Brother Shafat. Then I'll give you maybe some examples of the bill to illustrate, of the order to illustrate some tensions.
Yeah, Feroze, I'd like to emboss what you said, and I'd love Yusuf to even comment on that. The ulama are the custodians that will apply the law and allow justice according to divine decree. Beautiful indeed. And perhaps the circular law wants to take the ulama out of the equation, out of jurisprudence, and they want to put in the agenda. And, today you can see the secularists deliberately want to question everything which, opposes them and oppose the agenda that they have. They love to bulldoze divine decree. And when we search for values, as Advocate Feroze Boda said, when we search for values, we look back, we look at the Quran, we look at the Sunnah, we look at the Sahabas, and when the secularists, when they look forward to their thing, they move forward, bulldozing divine decree and implementing a godless society. They're taking, Allah out of the equation. They're taking away people, and they're bringing them into this hedonistic world, this world of materialism. We're going back to paganism. They're all going back to paganism. And Advocate says it so eloquently when he says, stand fast and obey the law of Allah subhanahu wa ta'ala. Every Muslim should defend the deen and protect the deen. And this is why we are here. And perhaps, inshallah, we are being documented as those this evening are defending the deen. May Allah accept that from us. Attorney Yusuf Docrat, your comments?
Shafat, Feroze, very difficult to add to what Feroze has done. It's been quite inspiring and comprehensive, alhamdulillah. Two very brief points I'd like to just make. And Feroze has in fact alluded to it towards the end of what he was saying. We mustn't be naive about the way in which legal matters sometimes arise, the way in which issues are raised at the level of social discourse. Modern societies operate on the basis of lobby groups, and it's considered quite an acceptable way with which to advance interests. And so we mustn't be naive about why these issues are then placed on the agenda. Why do they come to court? Why are they being raised here? Why are they being raised in other fora? There are elements within society that seek to change the Sharia. They've been quite open about it. And it's just to look at some of the literature that's available, and you'll see. So Feroze has made reference to those ridiculous criticisms of patriarchy within the rich jurisprudential history of Islam. And of course that kind of criticism creates a narrative. And just as we saw on the issues of the closure of the masajid and the issue of resisting attempts to alter the sunnah method of performing salah, where a narrative was created that people who sought to protect the masajid, its sanctity, and the way in which salah must be performed, were then accused in a narrative of not being careful, being reckless, being irresponsible, not caring about people, so on and so forth. That's the characterization that is used then to undermine those who stand firm. And in the context of this MPL, you'll find that the narrative that's being punted is those who don't want to have this are actually patriarchs who want to continue with the exploitation of women. And that is a narrative that we must be aware of, and we must reject it. We must reject it because we are from the Ummah where Allah has ordered us to obey Him, to enjoin that which is good, and to forbid that which is evil. And subhanAllah, this afternoon I asked a brother just in passing, just for his nasiha, on what he thought I should say or raise, during our discussion, and he made the following point, and that's really what I want to conclude with. He made the point that when we deal with Sharia, we must not seek to find avenues to reduce our obligations. So the first principle, don't seek to find avenues to reduce your obligations, fulfill them. And the second principle, he said, is don't find ways to increase your entitlement. And if you look at the way in which society pans out in its conduct, you'll find that those two elements exist. So we must, as an ummah, sami'na wa ta'ala, when Allah says something, we must obey. And we must obey instinctively, immediately. And with the brothers and sisters around us, those with whom we have familial relationships, over whom we exercise a degree of authority, we must be encouraging the good and forbidding the evil. And if brothers and sisters are out of check, we must be advising them in a good way. We must be taking responsibility for this ummah as an ummah. We cannot expect the land of disbelief, the proponents of disbelief, the institutions of disbelief, the police of disbelief, to be enforcing the morality of Allah's law. This is our responsibility. And inshallah, Allah will bless us, will give us hidayah in which to do that, so that we will, as brothers and sisters in this deen, help each other ultimately to obtain Allah's mercy and inshallah to reach Jannah. Jazakallah khair.
I tell you, Yusuf, mashallah, indeed. I just want to summarize that, and I'd like to emboss it so the listeners will get a clearer picture what's going on here, and our advocate will take over. Our attorney Yusuf says modern societies, advance issues with lobby groups, and this happens all the time. The narratives are created to undermine those that are firm, and it's happening all the time. This is the story of mankind. This is a story of every Nabi was undermined, but alhamdulillah, truth comes to the fore, and we must reject them, as Attorney Yusuf says. When we deal with Sharia, don't find ways to reduce your obligations. We must obey instinctively. We must encourage good and forbid evil. Our responsibilities is with Allah subhanahu wa ta'ala. Allah will bless us, and if we do everything right. Advocate Feroze Boda, your take?
Jazakallah khair. I think Yusuf has just captured it so beautifully that, the solution to the problem of injustice in our society and within Muslim families, and we shouldn't put on blinkers and say there is an injustice and there aren't women who are not being treated in accordance with Allah's laws. Yes, they are, and there are men and there are women who are being treated with Allah's laws. Our obligation is not to delegate the Amr bin Ma'ruf, Nahya anil Munkar to somebody else, but as a community to self-enforce that. And we can do that. We can do that if we have a will, and we can make sure that zulm is taken out. But the alternative of delegating the task of ensuring justice in family disputes to the legislature, the secular legislature, and the secular court is the corruption of Sharia. And that has to be the first duty to protect. Before anything else, we protect the Sharia. And so I'm going to give you some examples of how, from the Supreme Court of Appeals interim order, there's a complete distortion, corruption, in fact, derecognition and secularization of a Muslim marriage. So one of the things that the Supreme Court of Appeals said was that, the tenets of the Sharia law of deceased persons and seek to claim benefits from a deceased estate in the provisions of the Interstate Succession Act and of the Maintenance of Surviving Spouses Act. So basically what they said is that in the interim, for the purposes of interstate succession, Sharia marriages must be recognized for purposes of that. So that sounds great, but what does the Interstate Succession Act say? So as far as I recall, I don't know the figure, I'm not in that field of law, but when I recall in my studies, the Interstate Succession Act said that if a deceased person dies and left 250,000 rands in his estate, then the wife has the claim to that first. And if there's more, then the children will divide it equally among them, or so she'll get 250,000 rands or a child's portion. So the first inheritor in the Interstate Succession Act is the wife. And if the estate only has 250,000, she gets everything. So in a situation where the deceased has got parents, a mother and a father, has got a wife, and has got a son and a daughter, for example, the Interstate Succession Act will disinherit the mother and father and son and daughter and give everything to the wife. Now that is complete zulm. It is completely un-Islamic. The Interstate Succession Act is un-Islamic. So how can you subject a Sharia marriage to the Interstate Succession Act, which is at its core un-Islamic? It's mixing oil and water. It's changing Sharia. It's de-recognizing Sharia. It's secularizing Sharia. At least the old apartheid government were honest, They said, look, we don't recognize your marriage because we believe it's against our values, whatever their values were. If that's the view of the government, today's government, that the Sharia contradicts the Constitution, then they must tell us straight in our faces that that's what they believe and not recognize it. So at least that's honest. That's not trying to cloak recognition in a disguise of really derecognition. Cloak it by saying in one breath we're recognizing it, but we're going to change the legal consequence of it in every single area that we know. We're going to subject it to the Divorce Act and the Interstate Succession Act. Another example, the court said that the Divorce Act and the Maintenance of Surviving Spouses Act is applicable while to deceased estates and to divorces. Now, in Sharia, there's no reciprocal duty of support. No man can take his, as far as I know, or maybe I'm wrong, I'm not an alim, but my knowledge and what I've learned from ulama is that a man can never take his wife to a Sharia court for maintenance, either before, even after divorce, or during the iddat period. A man has the sole responsibility of surviving, of supporting his wife and his family. There's no reciprocal duty of support. Under this act, a man in an Islamic marriage can go to court and sue his wife for maintenance and claim maintenance even after the divorce, because the Divorce Act allows for maintenance orders to be made after divorce, even though the duty of support is terminated. So this is now completely incompatible with Islam. These are just two examples. There are many more, Brother Shafat. And this is why you cannot mix the two. You cannot mix the two. You cannot codify the Sharia. You cannot make it into English legislation and ask courts to interpret it fairly. It's going to be corrupted from start to end. And these are just two examples, inshallah, that I've given you, which illustrates the difficulties and the corruption and potential corruption of Sharia law by secularizing it in terms of a codified statute.
Absolutely, mashallah. Yeah, protecting the corruption of we need to protect it, as you say, and you're quite vociferous about that and gave us a few other things. We should call a spade a spade. Circular law contradicts Sharia, period. Time for us to go for a break, and inshallah, we will continue after that.
You're listening to Marcus Sahaba Online Radio Podcast.
Yes, sir, the program is Legal Talk, and alhamdulillah, we having a marathon session, but I tell you, it's beautiful listening to Advocate Feroze Boda and also our attorney Yusuf Docrat, already filling us in with so much of information. Advocate Feroze Boda, before the break, we spoke eloquently about the protecting the corruption of Sharia and secularization of Muslim marriages and how this is affecting everything. Interstate Succession Act is against Sharia. We should, maintain the maintenance orders that can be taken, after divorce has taken place. A husband can sue the wife, etc., and so forth. Continue, Advocate Feroze Boda.
Yeah, so I was just giving an example of a husband suing a wife, which is completely unheard of as far as I know. I may be wrong. I mean, another third example is the idea that you can force one spouse to maintain the other spouse beyond the iddah period. Now, there may be schools of thought who have tried to modernize Islam and change it and say, reinterpret it, because many people are of the idea that, the fiqh, as we know it from the established scholars of this deen who spend their lives interpreting the Quran and beating it to death, the fiqh is very much, according to traditional Islam, part of the essence of Islam. So there's this idea that because, and some people justify it like this, they say, well, fiqh is man-made. Fiqh is man-made, and therefore everyone has a license now in their own times to reinterpret fiqh and family laws. But the family system was always the same in Islam, and really the idea that we must now separate from the jama'ah, the jama'ah of our traditional scholars, the bedrock of certainty that this ummah has given us over coming to Sharia positions of law over centuries of consideration, is really, in my view, inimical to Islam and does not recognize the ijma of scholars as a very much part of the sources of law of Islam. And yes, there is a place for urf and a place for custom when these things don't inform the position. But all matters of Muslim personal law have been basically codified, established in the books of fiqh with unanimity around obligations of husbands and wives, around maintenance issues, around custody issues, and all of them have really deferred the matter to people with knowledge in Islam, the ulama, who decide these matters on a case-by-case basis. So not only do we see a tension between the substantive law, if you try and merge oil and water, try and merge Sharia with secular law, and to try and codify it in a statute which now must be compatible with a Bill of Rights, which is not in accordance with Islam in many respects. You find a tension at the level of substantive law and a corruption of the deen, but you take away the role of the ulama as the judges, and that is what they should. That is their role. Our ulama deserve respect. They have studied many years in the Darul Ulums. They've devoted much of their time and efforts to understanding the deen. And where we find that we trust ulama, we should be bound by their decisions. Why aren't the other religious denominations in South Africa going to court to say we want a law, a Jewish personal law, or a Hindu personal law, or a Buddhist personal law? Why aren't they doing this? Because they don't want to corrupt their values. They understand that the two cannot be mixed, and you're going to have a tension between the constitution and their law, and you're going to entangle the court into doctrinal issues, which is not the business of a court. So why are we doing this when what we should really be doing is giving the ulama in our society, those who have been, communities have placed ulama into certain positions, our communities, and we've survived like that for many years in this country. And the idea that they cannot be objective and that they cannot give fair decisions is, with respect, untrue and a generalization. Every legal system, you're going to have judges who don't apply the law properly, or who give decisions which are wrong. You think you're going to go to a secular court and not avoid incorrect decisions, or not avoid decisions which you perceive to be unjust? Then you're living in a utopia. Because wherever you go, whether you go to a ulama body or you go to a secular judge, that person's human, that person can err, that person will have certain predispositions that may enforce or inform their judgments. But at least when you subject your dispute to a Sharia system, you know that the person judging the dispute is not at the first instance going to use his reason to make the decision, because his reason is irrelevant when there is clear Quran and Sunnah and Ijma on these matters, and that serves as a check and balance against hawa and injustice. And that is a safer system to ensure justice than a secular system where basically a judge will apply whatever reasons they want, and will also be predisposed in one way or the other to one set of value systems or the other. At least the Sharia puts a check on judges. And judges in the Sharia are warned about their duties. There are hefty responsibility placed on those who are pass judgments in family disputes to ensure justice. Very, very heavy responsibilities. And here again, the judges that sit in to make decisions in Muslim personal law matter, their first responsibility is to fear Allah, because they need to know that they're going to be held accountable for their decisions in the court of Allah if it leads to injustice, or they are informed by some sort of a bias which is not acceptable in the deen when they give judgments. So they have to fear Allah, and we trust that our ulama. I mean, we have differences of opinion, but whatever ulama have been traditionally playing the role of judges and giving judgments in Sharia disputes, they do it bona fide. They do it, and we must assume and trust, like you trust the appointment of judges, that when a judge is appointed in a secular court, that judge has a certain amount of morality or moral fiber, but it can never be guaranteed. We must trust our ulama. We must trust their judgments. We must trust that they're applying what they believe to be the Quran and Sunnah, and we must accept their decisions. We don't go on questioning secular court decisions. We accept it as a matter of fact. If the Constitutional Court tomorrow rules A, well, that's the law. If you don't like it, you don't like it, but that's the law. You can't question that. You have to respect it. You have to obey it. If tomorrow the government passes a law, a traffic law, that says you must drive your car in a residential area at 40 kilometers, you can moan, you can groan, you can say it's unjust, but if that law is passed, you obey it. And that's it. And that's how you regulate your society. At least as a Muslim, you can say to yourself, I've held myself bound to a decision which was applying the law of Allah and the hadith and the ijma of the scholars, rather than trying to find fruits from another system which does not apply that law, which does not recognize the deen, which does not recognize the power of Allah, the role of the messenger, the akhirah, the day of judgment, Jannah and Jahannam. None of these things are in the mind of a secular judge when they're judging. So we should, we can improve our internal fixed systems. We can improve the way decisions are made. We can get people trained to render their judgments in accordance with proper due process recognized by the Sharia. All of these issues can be ironed out internally. There's no reason to take the Sharia and subject it to a secular system. And that is the concluding remark I have, Brother Shafat. I don't know if Yusuf wants to round up now.
Yeah, I think, definitely we need to bring Yusuf in here, because what you have said is brilliant indeed. There was always the family, and there was always the ulama there. Everything ran smoothly when there were issues pertaining to deen. We went to our ulama, we went to the muftis, and there were, fatwas passed, and the obligations of family matters is, handled by the ulama, as I said, and as Advocate Feroze Boda said it so eloquently. And who judge and who make a decision going through a divine decree or the books that are in front of them, and which are being approved by by the jurist or the Muslim jurisprudence. And look at the African, the Jews, the Hindus, as Advocate Feroze Boda says, they're not going to court and fighting over all these issues. They know that the secular state cannot handle the issues, and that issue of religion or what they obey, they know cannot be judged by a secular court. But why are we going there? Why are we going there? We both claim to be the custodians of the deen, but we're putting ourselves there Muslims fighting Muslims. I recall long ago Kramer versus Kramer, but that's still by the way. And all this is coming. So we should submit our objections with the Sharia court, where the Qazi, the judge himself, is of sober mind, is looking at the divine decree, looking at the Quran, he's looking at the Sunnah, and making an informed decision that will please Allah subhanahu wa ta'ala. Whereas when you go to a circular court, we don't know what mood or what type of mind the judge has, and then he's making that decision according to his mood, according to mood swings or whatever. But we, alhamdulillah, and finally when Advocate Feroze or Boda says, when the circular court or the government brings up or puts a certain fine, if you hit the red rover, you're going to pay 2,000 rands. So you disobey traffic laws, you're going to be fined. If the price of fuel go to 20 rands a litre, you can't object because that's the law of the land. So, he's making a lot of sense. And here we bring in our, attorney, Yusuf Docrat. Your thoughts, dear brother?
Shafat, very, very briefly, Feroze really seems to have covered absolutely everything, alhamdulillah. Just to endorse two or three of the concepts he's raised. The one is, we need to have enough self-respect and enough true belief and respect in the perfection of Allah's law, in its universality, in its timelessness, in order to inculcate a desire to establish that law wherever we are. So that's the first. And what goes with that is to relegate any other system within our minds to something subordinate. Right now, after hundreds of years of colonial rule, of being without a khilafah, with all of these issues, we've done the very opposite. We have placed above the divine the created law. We have placed above the pure the law of filth and impurity. We need to reverse that mentally. This is a very important process that each Muslim has to go through, and it's an eternal battle. It's something we're going to have to deal with every minute of every day of our lives. Keep checking that we do, in fact, place Allah's law above everything else. These are not just slogans, not just words. These are questions of belief, true belief. But they manifest practically, because once we do that, what follows from it is what Feroze speaks about, the amal bil ma'aruf, the enjoining the good, the forbidding the evil, the self-regulation of a society that begins to progress organically towards a purpose. What is the highest purpose? Is to fulfill Allah's lordship in this world. So with that understanding, we self-regulate and we improve our societies. And thirdly, at a practical level, we empower the ulama. Further, we give to them back what we have taken from them unfairly in the last 10 to 20 years, is the status and the legitimacy as scholars and people who understand the law of Allah, so that they with confidence can speak, so that they are not pushed on the side and everybody with a secular university degree of 3 years or 5 years thinks that they have become the new experts in Sharia. We need to start recognizing our own place. I do not hear lobby groups in the Muslim community attacking Roman Dutch law in its roots, asking for its reinterpretation and X, Y, and Z. There's respect for all of those things. But we hear every single day people wanting to re-engineer the Sharia. We have no respect for it. And if we have no respect for Allah's law, what are we saying about our view of Allah? So, Brother Shafat, recognizing Allah, recognizing His divinity and the universality and timelessness of His law, implementing in a self-regulatory fashion through amal bil ma'aruf and encouraging the good and forbidding the evil, getting our society to get better, and then empowering the institutions that are, as Feroze has put, the custodians of the law, so that inshallah Allah will be pleased with us.
Suma, beautifully said, self-respect and establishing Allah's law. And I think we've been very vociferous about that. Without the Khalifa, we have allowed circular law to colonize us and perhaps colonize our mind and the way we think. We need to introspect, as Attorney Yusuf Docrat says. We need to introspect. We must fulfill Allah's lordship. And, we are Allah's vicegerents on this earth. We shouldn't be sinning against our intelligence recognizing Allah's divine decree, and that the whole thing that, our Sharia is given to us as a mercy from Allah subhanahu wa ta'ala. And, Attorney says it so beautifully. He says, empower the ulama so they speak with confidence. They've been shaken around, they've been, picked at, and other people that do not have the education or even the qualifications are picking on them. And we should be, inshallah, embracing them, celebrating them, and giving them the confidence. And we hear every day, people want to re-engineer Sharia. They all have, different agendas. And perhaps earlier on, we said that we must be careful of lobby groups that are doing this to cause disunity in the Ummah. We have about 8 minutes to go. Advocate Feroze Boda, and you started off the show, and perhaps you'll be ending of the show with some of your rounding up. Go ahead, Bismillah.
Brother Shafar, I think I've actually exhausted what I want to say. So, just to basically summarize, I think it's quite clear from the position that Yusuf and I have advanced, and many organizations have advanced. Wifaqul Ulama, Muslim Lawyers Association, EMSA, all of them have advanced the position that we should not delegate the task of enforcing the Sharia to the secular state, because it's going to secularize the deen, change the deen. They do not have the capacity, they do not have the expertise to try and even interpret or to try and give justice to people in Sharia. They are ill-equipped. They are not, the judges don't know Sharia law. They don't know Arabic. So the decisions that you're going to get from them are not going to be in accordance with the Sharia. So this idea that we should delegate the task of ensuring justice in the realm of family law to the ruler is something that we should not agree with, that we should resist. And in order to ensure that people within our communities are treated justly, we should empower the ulama, and we should get together and we should self-regulate and ensure that all oppression from our societies in the family unit, in specific circumstances, oppression against brothers, oppression against sisters, whatever they are going through, that we root it out as a community and we take responsibility for our actions. That is really the concluding remarks I want to make. Jazakallah khair, Brother Shifa.
Jazakallah khair, Advocate Feroze Boda. You were the one that engineered the show, and I can tell you, with a positive lobby group, Mufti A.K. Hussain involved, and Yusuf Docrat. Yusuf has just left us, and he's gone to pray some extra salah. Allah bless him too. And I tell you, Advocate, all right, Yusuf, have you left us? All right? Okay. Yusuf is gone. Alhamdulillah. Well, Advocate Feroze Boda, always a pleasure having you on the platforms of Markaz Sahaba, the voice of the Ahl Sunnah wal Jama'ah. Inshallah, we'll talk to you in the near future. And Assalamu alaikum wa rahmatullahi wa barakatuh to you.
Wa alaikum salam, Brother Shifa.
Yes, absolutely. Brilliant people. Keep it locked on to Markaz Sahaba for beautiful programming and, lots of knowledge coming through from the team and I. Till we meet you again, we bid you Assalamu alaikum wa rahmatullahi wa barakatuh.